Hello, my name is Diego Nunes and I'm a professor of legal history at the Federal University of Santa Catarina, Brazil. This is part of the video series called History of Criminal Law on Video. Its aim is to gather experts on the subject to present a short synthesis based on their research. Enjoy!
In this presentation, I will make a short introduction to the codification of criminal law, not just for one specific jurisdiction, European or American, but concerning to the Western legal tradition. The first thing we should explain is this idea of codification. And then, in the second part of my presentation, I will try to deal with the contribution of codification to the development of criminal law. So the situation of law in the 18th century was a bit chaotic. If we need to summarize in just three expressions the situation of criminal law, even the situation of law in general perhaps could use three expressions. The idea that the law was inaccessible, the law was complex, and the law was uncertain. It wasn't inaccessible or difficult to access because the law was spread in different laws from different legal norms, different chronological contexts, and it was difficult to find, even to find the legal rule applicable to a specific case. It was complex because, connected to what it has been said, if the law should be found in different places and different laws from different social and political and chronological contexts, with some contradictions among the laws, it was complex to figure out what was the legal rule applicable to a specific case. And these make the law uncertain. So what is going to be the final judgment of this specific case? So that was a problem for the whole Western legal tradition, both the civil law and the common law tradition. So the law needed to be reformed. 18th century is the period of legal reform. And legal reform encompassing not only the formal aspect of law, but also the substance of law. So formal dimension of law would be something like, why do we need so many laws? Why are laws so dispersed? Why is such a legal, we could say, disarray? Why is it so difficult to find the specific legal rule for a case? So, but then there are problems concerning the substance of law. So why our laws, in our case, our criminal laws, were so old-fashioned? Why are criminal laws so harsh and severe? Why are criminal offenses so ill-defined? So broad somehow? Why are punishments so disproportionate to offenses? Why are punishments transmitted to the offspring of the convicted? So this problem of legal reform appeared in the 18th century. And in fact, in the 18th century, we have several codes that were promulgated in different European jurisdictions. But these codes could be called enlightened codes. They are not the 19th century liberal codes. And what are the differences between these codes promulgated in Europe in the 18th century? And these are the liberal codes I would like to touch upon in a particular way in this presentation of the 19th century. Well, these enlightened codes were promulgated because these problems of the legal system. So they were approved by monarchs, in the context of absolutist monarchies, encompassing all legal branches, not just the criminal laws, but one code could encompass all branches of laws. The application of the principle of legality was not very strict, somehow was a bit flexible. We could even think too much flexible or too flexible. And the idea of equality was not at the forefront of these codes, because we have these different social states, depending where you were noble or you were a free man, etc. The legal regime, the punishments were different. So the modern codes, perhaps the first example of modern code were the Napoleonic Codes. So all the liberal codes coming after the French codification were different. Why? Because they were not approved by the monarchs. They were approved by parliaments, according to the idea of the national sovereignty, that the power resides on the people and not on the monarch. Then, in the context of a political system, different political system, not the monarchies, but liberal system, and codes in the 19th century encompass just one legal branch. So we have civil codes containing all all private laws, either the civil code or the commercial codes or the mercantile codes. We have the criminal code or the criminal law procedure or the civil law procedure. All these legal branches had one code. And then the idea of the principle of legality was very important after the constitutionalization of this principle, which was at the forefront of the new legal system, and also the principle of equality. There were no distinctions between, depending on the person who was to be convicted, different punishment for different people, but the same punishment for all the people. So the idea of the codification then was to make a new law encompassing all laws concerning one legal branch in a different way. So what was the contribution of the codification to the development of criminal law? So the French Revolution claimed for several principles that should be changed. The idea that the excessive application of the death penalty, some punishments that were too harsh, besides the death penalty, like the confiscation of goods, the application of the degrading punishments whose main function was to degrade, to humiliate the convicted, the application of torture as a means to get the evidence, because the confession was very important. So in order to get the confession of the person who was in the process, so they tried to get the confession through this means of evidence that was the torture. So all these ideas, from the substantive perspective of criminal law, it was thought that they should change. There was other principles, important principles contained in the codes, in the criminal codes. The principle of legality, the idea that laws should lay down perfectly what was the specific behavior, conduct that should be criminalized, and what would be the consequence of committing this crime. So what would be the specific punishment for this specific crime? Or the idea of the proportionality between the crime and the punishment. That was an important aspect, because in the context of the political, of the Ancien regime, the absolutist monarchy, somehow they abuse pretty much punishing too much some specific behaviors that wouldn't deserve these specific punishments. So other ideas or aspects, substantive aspects of criminal law that should change is the idea of the individuality of the punishment, which means that the punishment should be applied only to the person who really committed the offense, the criminal offense, or the principle of the favorable decision. So this principle in Latin is said in dubio pro reo. In case of doubt, what would be the best way to judge this specific case? So let's do it in favor of the person who is at that moment in the process, in the trial. Or even the principle very well known today, which is the presumption of innocence. The presumption of innocence. So this person, unless it's judicially proved that has committed this crime, he should be treated as a person who did not commit any crime. Once the process or the trial served to give evidence of the commission of the crime, then this person can be condemned. So the codification of criminal law, or in fact some of the discussions, the codification of law, there are three big discussions, and then with this discussion, just presenting them, I will finish this brief presentation. The big discussions are the following ones. The first, the idea whether the codification, the criminal laws contained in the codes, constituted a break with the past, or somehow reflect a kind of reform, or in some aspects even a continuity with the law of the past. This is one of the big discussions. The second discussion is the foreign influences versus tradition. In other words, whether the content of the criminal codes reflects the tradition and the past of the different jurisdictions, or the content of the code was highly influenced by foreign influences. For example, the case of France. We said that France was the first jurisdiction, European jurisdiction, to undertake a modern codification. So to which extent the other codes somehow copy some parts of this code, so these other jurisdictions did not follow their own legal traditions, but the French legal tradition. That is the second discussion. And a third important discussion about codification is whether one of the main reasons of codes, of codification, was to undertake legal unification. So let's leave aside the idea of trying to accomplish legal unification through codification, because I think in criminal law it's quite clear that in all jurisdictions all the laws were unified. But we could say brief things about the other two aspects. What about the break? So the idea behind that the content of the criminal codes constituted a break with the past, the idea comes in a particular way from a cultural reason, from a philosophical reason. What is the philosophical reason? The philosophical reason was use rationalism. This legal theory that defends that the law should be the product of reason. So we don't need different laws depending on the history and the past and the tradition of each particular territory or jurisdiction. So laws can be discovered through reason. And because all men share this rational dimension, the same laws should be common for all the people, no matter the origin, the geographical origin or the nation to which these people are attached. So of course there were another different way to see that, the idea of that the law should be the product not of reason but of history. So we have here two different approaches to law. The use rationalism approach, so all laws should be the same for all the people, no matter their geographical origin, or the idea, the historical or romantic dimension of law. So law should differ depending on the geographical, traditional, or cultural background. So we don't have time to try to explain this as perhaps we would need, but the idea is that if you have a look at all the laws before the codification and you take into account the huge influence of the jus commune that was precisely this legal science common to all Western legal traditions, and you realize that many of the categories contained in the criminal codes came precisely from the treatises elaborated by civil lawyers and canon lawyers, the corpus juris civilis and the corpus juris canonici. Many of the principles that were contained in the codes were present, were contained in the modern criminal codes. So from this perspective, we shouldn't say that the content of the criminal codes constitute a break with the legal tradition, a break with the former laws, a break with the compilations drafted in the context of the Ancien Regime, or even more important, they are not against the treatises published for jus commune lawyers in the 15th, 16th, and 17th centuries. So this means that somehow we can answer the second question, whether what was the balance between the tradition and the foreign influences. So I would say, even if some aspects of the code, for example, the distribution of the structure, the distribution of the books and the titles, might be quite similar to other codes, and you may come to the conclusion that they follow a foreign code. If you consider the content, the provisions, the articles contained in the codes, some of these articles, some of these categories, many times came precisely from these categories, from these principles, from these definitions given by the jus commune lawyers before the codification movement. So then what was, and this is the final part of this presentation, what was then the main contribution of the codification to the development of criminal law? So I would summarize the main contribution with these three ideas. The main contribution of codification to the development of criminal law could be summarized in three ideas: systematization, secularization, and humanization. Systematization is quite clear. because rationalism was present. And the idea of system connects with the idea of trying to give a structure. In fact, the division or the divide between the general part and the special part contained in all criminal codes, in all modern criminal codes, is a sign that the importance of systematization. So, and even if you have a look at the general part of the codes, so this idea of, well, the definition of the crime, what is a crime? The classification of crimes. There were classification of crimes in Roman law. Delicta atrocissima, gravis et levis. And these distinctions somehow appear in the codes. They differ from one code to another. The French code put 3 different kind of criminal offenses: crime, délit, and contravention. But other criminal codes make different distinctions. So, but this idea of defining the crime, to classifying different kinds of crimes, the idea of the guilt, the principle of guilt, distinguishing whether there is a criminal intent, the different kinds of dolus, criminal intent, or just committing a crime by negligence, or the idea of self-defense. So all these ideas, perfectly structured in a general part, is one of the contributions of the codification movement. But this does not mean that all these categories were a creation of codification. No, the codification served to put all these categories coming from the jus commune tradition in a way, in a clear way, in a structured way, that no laws from the ancien regime ever did. So, the other idea, humanization. It's true. Some punishments were very harsh. In the codification, there was a process, a slow process. Some liberal codes contain harsh and very severe punishments. We shouldn't forget that. But with the passage of time through the codification movement, throughout the codes, punishments were very severe, were more humane, you could say. So, in the idea of secularization, some authors stated that in the ancien regime, before the codification, before the enlightenment, we could say, the crime had 3 elements. The element that it was a behavior that went against the victim. It produced a damage to the victim. It produced a damage to the society, to the whole society, and it was against the gods. So this idea that a criminal offense somehow produced 3 damages: damage to the victim, damage to the society, and damage, we can say this way, to God, because it's an offense to God. So this idea of putting God within the criminal law system is one of the things that codification contributed to improve, or at least to take this part away. One of the consequences of this, some of the crimes connected to religion were abrogated, or blasphemy, for example, or we could say adultery. So this is a complex aspect that we don't have time. I have to finish this presentation, it has been longer than I wanted. But the idea is that the secularization process means that we have to distinguish as much as possible, but not completely different, because there will be always relations between morality and law. We have to distinguish the idea of a crime, the criminal offense, and the idea of a mortal sin. There are mortal sins that will never be a crime, although most of the crimes normally are or constitute a mortal sin. So then, in my view, and this is the last statement of this presentation, the most important contribution of codification to the development of criminal law could be summarized with these three ideas: systematization, humanization, and secularization. And the codification of criminal law did not constitute, in many aspects, a break with the past. We could say that codes serve as a way to integrate many of the definitions, the categories, and the concepts present in the jus commune tradition, as it happened with the civil codes.